Good morning, Dr. Fenech. As the managing partner of Fenech and Fenech Advocates, today we'll be talking about ship arrests. As a marine litigation lawyer, are you involved in ship arrests?
Absolutely. I would think all marine litigation lawyers in Malta would be involved in ship arrests because naturally Malta's geographical position, bang in the middle of the Mediterranean, plus the fact that we have a very busy ship repair activity, we have a very substantial transshipment centre. All of these ingredients and so many more lend themselves to vessels actually coming to Malta. So yes, Malta would be a good jurisdiction for the purposes of arrests.
Under what circumstances can you arrest a vessel under Maltese law?
That is a very interesting question, which has been through quite a number of changes over the last number of years. Historically, well, to start off with, Malta is not a signatory to either the 1952 Arrest of Ships Convention or the 1999 Arrest of Ships Convention. Before 2006, the grounds upon which one could arrest a vessel were intimately tied up with the grounds of jurisdiction of our court. And therefore, in other words, if our court did not have jurisdiction over the merits of the case, then it would not be possible to arrest the vessel. And our courts would have jurisdiction over a case either in personam, which is against an individual or a company, a person, or in rem against the vessel. Focusing on in rem jurisdiction and arresting a vessel for the purposes of securing an in rem claim, before the 2006 amendments, believe it or not, we had to look at a fairly archaic piece of legislation, the Admiralty Court Act of 1840 and 1861, with the very limited grounds contained in those Victorian acts, before one could decide whether or not one could arrest a vessel. Obviously, life has changed enormously since 1840 and 1861, and there are so many further grounds upon which one ought to arrest a ship, which weren't available under Maltese law. Apart from that, in 1995, we had what we call the poker cases. I was involved acting for the vessel Poker. The Poker was a vessel which was bareboat chartered to a company, and the bareboat charterer had entered into an enormous amount of contractual arrangements with various providers. The bareboat charter disappeared off the face of the earth. He never paid his contracting parties. The Poker ends up in Malta, and the Poker is arrested by the service providers. I believe there were 6 separate cases in the Poker cases. I had made the point at the time that although Maltese courts had jurisdiction over the merits because it was a matter of necessaries or supplies or services to the ship, we felt it was totally incorrect and wrong for a provider of services to be able to arrest the ship in rem, and yet when the action on the merits, when the liability for those claims were not entered into by the owner of the vessel but by the bareboat charterer. And the case we put up was the following. At the end of the day, if the owner of the vessel doesn't pay following an arrest and following an action on the merits, and the vessel is in fact sold in a judicial sale by auction, who is the person who is going to suffer that sale? The person who suffers the sale would be the owner of the vessel because he is deprived of his asset. But is it fair that an owner should be deprived of an asset when it is not he who would have entered into the commercial arrangement to start with? There was no law on this. We made law through case law, and the courts and the Court of Appeal decided that that the vessel Poker ought to be relieved from any form of responsibility. But there was no law, it was case law. So it was decided in 2006 to amend our Code of Organisation and Civil Procedure. I have it here in front of me. As you can see, it's seen better days, but I refuse to allow anybody to touch it because that's 34 years of cases in the making. And our Code of Organisation was amended. Section 742 was amended. We introduced the grounds of jurisdiction in rem. I actually drafted Section 742. And when we put all the grounds of jurisdiction, we used as a source the 52 Convention, the 99 Convention, and the English Supreme Court Act. So today, although we are not signatories to the 52 or the 99 Convention, we actually have all the grounds of jurisdiction in rem, which therefore are also leading to the possibility of the arrest of a ship, found in all of these different international conventions.
Do you have to put up counter security when you arrest?
No. Under Maltese law, once you establish the presence of the vessel has to be present in Malta, and the action on the merits needs to be one of the grounds found in the Article 740, which I have just described. You can proceed with an arrest, provided that within a period of time you commence an action on the merits, and I'll be saying something about that in a moment. However, in direct response to your question, we do not have to put up counter security. With regard to the commencement of an action, if the dispute on the merits is a contractual dispute, and in the contract you would have an arbitration clause, then you would not actually have to commence the action on the merits in Malta, but you would be permitted to commence the arbitration in line with the governing clause in your contract. If it's not an arbitration clause, and if your contract points to an EU court, then the Brussels I recast, the regulation, would allow us to arrest the vessel in Malta, and then the action on the merits would take place in a European court as indicated in the Brussels I recast. So more or less that is the situation.
How can you lift an arrest?
Well, obviously, the sole reason behind an arrest is so that the arresting party obtains security. The arrest can be lifted immediately if the person whose vessel would have been arrested puts up the equivalent of money that is being claimed in court. The law is clear that if you put up cash or if you put up a bank guarantee drawn on a Maltese bank, then the arrest is lifted immediately. Of course, in the world of shipping, it is very common for P&I clubs to put up security. However, there is not an automatic lifting. The P&I club letter of undertaking has to be agreed by the arresting party. If it is agreed by the arresting party, then it is lifted automatically.
Can you be found liable for wrongful arrest?
Well, yes, you can. Under our law, we have loads of sections in this Code of Organisation and Civil Procedure which allow you to file an application requesting the court to revoke the warrant of arrest on a number of criteria, either if the arrest wasn't necessary or if the action wasn't commenced within the stipulated period of time, or if the arrest is malicious or vexatious. Now, you can apply to the court to revoke that warrant. And very frequently, what we do as practicing lawyers is we first ask the court to revoke the warrant. And in the alternative, we ask the court to order the other side to put up security in the event that it is found to be a malicious arrest. Because our law provides that in the event that it is a malicious arrest, then the arresting party could be found liable for damages. But there are very specific circumstances, therefore, in which you could be found liable to damages. Arresting a ship, commencing an action, and losing the action does not necessarily entitle you to damages. There has to be a very good reason for that, and all these reasons are laid out in our Code of Organisation and Civil Procedure.